Hi again, everybody. I'm Rob Rosenthal with AskTheLawyers.com, and this is another episode of Ask the Lawyer. Today, we're going to ask the lawyer about divorce. If you've been through one, you know that very seldom does all end without lots of fallout, let's say. But my guest says it doesn't have to be that way. Attorney Chaim Steinberger, a divorce and family law attorney in New York City, says it's possible to have divorce without destruction. Chaim, thank you for making some time for us today. I appreciate it.
It's my pleasure to be with you.
So, divorce without destruction, that really is a thing that's possible?
Most people doubt it. By the time people get to us, they've become so frustrated with the relationship, they don't know how to deal with it, that they can't imagine any other way. People, when they come to us, feel that they have to fight. And when they call me, I say, you're absolutely right. If you keep doing what you've been doing, you're going to keep getting what you've been getting. But there is a better way.
And somehow you've explained, because this is an idea of yours that you've used for many years, game theory. How is game theory useful in a divorce?
So game theory is the mathematical study of how to motivate other people to behave in certain ways. So, for example, the Cuban Missile Crisis was game theory. And how do we make sure that we don't give other people the incentives to fight? So when strategizing on how to set up a divorce, you need to be very sensitive to the fact that you don't want to give the other side an incentive to keep fighting. You want to show them a way that giving you what you want is the best deal for them.
So it's making the other side feel like they're getting something as well. Basically, everybody gets something.
Well, okay, that's one way of putting it. But this idea so game theory teaches that when two people are working together collaboratively, they can both do better than when they have to behave adversarially. So when I'm negotiating against you and I don't trust you, I need to create a resolution where I can be guaranteed that you won't go ahead and screw me later. But if we work together, we can both do better. So while most people think of negotiation as a win-lose, where one side wins, for one side to win, the other side has to lose, Professors Fisher and Uri from the Harvard Negotiation Project in their groundbreaking book called Getting to Yes teach about how both people can win, and we call that a win-win resolution. Those are more difficult to achieve, and you have to be more sensitive and more nuanced. You have to listen to what people, not what they're saying they want, but what's really driving them. So, for example, a mother who says, I need that house, I might say, okay, Mrs. Smith, I understand that house is very important to you. Can you explain to me, can you help me understand why that house is important to you? And she might say, well, little Jimmy has ADHD and that school has a great program for it. And so now it's not the house that's important, it's a school district. It might not be the house, it might be living near her mother or her sister or her friends. So there may be other interests. And as we understand that better, we can now find resolutions. Maybe the other side doesn't mind if she gets the house, but it's the mortgage that's bothering him. And so what do we do? How do we allow him to refinance the mortgage in a way that makes sense for him, that lets her keep the house?
Right.
So by getting to the not the stated positions, but the interests of the parties beneath the positions, then we can find different ways to work out resolutions where they both win. And that's the basis of all mediation. I've been a mediator for more than 25 years. I've had people come into me who've been fighting for 3, 4, 5 years, who've spent hundreds of thousands of dollars on litigation, and in 4 hours and 5 hours, they're shaking hands and walking out. It's God's work. It's incredible. It feels like magic, but it's really not. It's understanding people, understanding what they want, and helping them get what they really want and need.
So does this concept only work in a case where both parties have agreed to mediation? Can it work when in a contested divorce when there's attorneys on both sides, or are there parts of it that can be applied to that?
So where the parties agree to mediation or where the parties agree to collaborative law, then you're halfway there, then at least they're in that mindset ready to do that. But I'm talking about even in cases where they come in as warring parties. So I've represented people I'm most proud of the fact of the cases where I was an advocate representing one side and I hear the other side say something and I go, I can play off of that. And I find a resolution where each side feels like they've won what was most important to them and my client got what was most important to my client.
So it's not necessarily a prerequisite that both attorneys buy into the process that you're talking about. Somebody needs to be aware of what's going on, but it doesn't need to be everybody bought in, at least at the beginning.
Well, absolutely not. So as you say, in other words, I'm not relying on the other side's goodwill to get this done. I am thinking, what can I do, sort of going back to that game theory, what can I do to motivate the other side? So sure, it's better if both of them understand the importance. We could sit around a table and we could say, okay, what's most important? What's most important is to preserve the ability to work together for the next 20 years. It's most important for us to protect our children. It's most important. I want dad to be happy and healthy and move on with his life. I want mom to be happy and healthy and move on with her life. So if we can do that in that way, that's terrific. Then we're halfway there. But I'm talking about even when not, by treating people with courtesy and dignity, but being no nonsense, understanding the law, understanding the facts so that you can sit there and you can answer the questions that they have. I was negotiating on behalf of a woman and the husband said, oh, well, you forgot about this and this and this. And I'm like, page 3, line 16. And he goes, oh, well, you forgot about that. I say, well, page 15, line 4. And ultimately, we reached a deal that was better than she had ever dreamed of getting.
When we start talking about money, and then especially money and children, and you talk about spousal support or child support, that can get especially contentious. Do you have a certain way of dealing with that to make it less so?
Well, it's sort of the same thing. It's of the same character. When you treat people with courtesy and dignity and you respect them, if you go over to somebody and you say, so opening to take the implicit assumptions within your question. If I'm representing mom and we're expecting dad to pay, and dad needs money for himself. And so I might start the negotiation by saying, Dad, mom realizes that you're the only father that these children will have, and she will protect and defend and make sure that you have a strong, reliable, steady presence in these children's lives. Can I assume that you want to support these children in a way so that they can grow up and be happy and healthy, so that they can have the shoes and socks and clothing and activities that all of their friends are having? And if we approach it in that way, if we approach it from a sense of fairness and dignity, most people will live up to the expectations that are set.
What about, what is your recommendation for parents when there are kids involved and the kids sometimes become a bargaining chip or there's a battle over what is your recommendation to your clients?
So here's what studies show. 2 parents can hate each other and stay together and the kids will be fine. 2 parents cannot get along, they can get divorced and the kids will be fine. The one thing that will permanently damage the children are a long, drawn-out, nasty battle. The longer the battle, the more drawn out it is, the nastier it is, the more permanent and the more deep the damaging effects on the children will be. So if you care for your children, you'll find a way, if at all possible, to make things work out. And there are often ways to get that done. So I've been in sessions where I looked to dad and I said, look, you have the right to move on with your life. You have the right to live in a way that's protected, in a way that you know what's going to happen. Will you agree that mom also has the right not to be fearful every time the children go with you, that she's afraid that you've been drinking again and you've been driving with the children when you're not completely sober? And if you create the atmosphere of goodwill where it's not adversarial, where you're not being accusatory, where you're not trying to put somebody down, but they recognize that you're doing it from a place of goodwill and mutual respect, then they will usually acknowledge the other side and say, yes, you know what, let's figure out a way to give mom the assurance that she's entitled to. Mom is entitled not to live a mortal fare. Dad is entitled not to live in a way where he can't afford to live in a decent apartment either. Let's figure out how we do that.
It makes so much sense, Chaim. It's unfortunate, I don't think very many people practice what you're preaching.
Not very many people do. As you know, Rob, I've worked at some of the largest law firms in the country. I clerked for a federal judge. I went through my own rather nasty divorce, and I said, there's got to be a better way. So I've now dedicated my life to practicing that better way. I've published the article in the New York Law Journal called Divorce Without Destruction. I just spoke several weeks ago at the American Bar Association Family Law Section Austin Conference on divorce without destruction, overcoming the psychological imperatives that make good people fight viciously. In other words, I contend that when people are fighting, it's not because they're bad people. People are fighting because they're scared. They're angry, they're hurt, but more importantly, they're scared. And when people become scared, the mind goes into self-preservation mode. The amygdala kicks in, the adrenaline gets injected into the bloodstream. And the human brain gets tunnel vision, where you can only see what you think is the mortal danger that's facing you. When you're in that mode, you can't explore other options. Right. You can't see what's going on. I spoke to a group of lawyers, and they all nodded as I spoke about this, and it'll soon be posted, my speech. But that was a talk to other lawyers. What can we lawyers do to help clients get out of this mortal panic danger sphere, where they can expand their horizons and they can start helping us find resolutions that meet their objectives, but that allow the other side to move on as well. Because here's the deal, and I've told this, I was an arbitrator in a case, and the parties have presented their cases, and I said, would you like to try to work it out yourself? And one of the sides looks at me and goes, why bother? You're going to render a decision. I said, yes, I know. I'm ready to render my decision. But if a court is going to order a father to pay $1,000 a month in child support, that father is going to mutter under his breath at the end of every month when he writes out that check. He's going to be upset about it. He's going to go back to court at every time he can. He may send the check out a little late. He may fight it whenever he can. If the father made his own decision and he feels like it was his voluntary decision to pay $1,000 a month, he writes the check more gladly. He feels pride in that check. This is a sign of my goodwill. This is a sign of how I'm doing the right thing. I'm doing the manly thing. I'm taking care of my children. Right. So that same outcome, if it comes as a result of it being pushed upon somebody, they do it begrudgingly and they fight it very often. And we call them the frequent flyers in the courthouse, the people who keep coming back every 6 months, every year, and they're back in court for another thing, either about seeing the children, about a modification of the amounts of money. But when a person makes that decision out of the grace and the goodwill of their own heart, they're more likely to abide by it, to live up to it. They're more likely to get along. And so it being in the line of work that I'm at, I've had people who've been divorced 5, 6, 7 years. They think they're out of it, and the drama just keeps going on and on. Now they're fighting about this. Now they're fighting about that. They have to change change custody at a police station because each one is afraid of the other one. And it shouldn't be that way. That's traumatic for the children. And it's traumatic for the parties as well. So if we can find a way where the parties make that voluntary agreement and they feel gracious as they live up to it, and they find a new way of working things out. They use this as an example to work things out and how to overcome problems that they have, so that when we disagree, it doesn't have to be a fight. We can disagree, we can talk it out, we can work a resolution to it.
Great. Thank you, Chaim. Thank you for the information, and tell us about divorce without destruction. I appreciate it.
You're very welcome. My pleasure.
That's going to do it for this episode of Ask the Lawyer. My guest has been New York City divorce and family law attorney Chaim Steinberger. If you want the best information about family and divorce law, or you're ready to choose a lawyer that lawyers choose, please visit askthelawyer.com. And also take a second to subscribe to our YouTube channel by clicking on the button at the bottom of the screen. Thanks for watching. I'm Rob Rosenthal with AskTheLawyers.com.